Good afternoon, everyone. Welcome to today's webinar on Constitutional Vision of Justice by Honorable Dr. Mohan Gopal, sir. With me, I have our guest speaker, Dr. Mohan Gopal, sir, and Joint Director of Maharashtra Judicial Academy, Sudhakar Yelagra, sir. Before I open the forum, I just want to share a few things. This webinar would be in a different format this time. Mohan Gopal sir has tried making it more interactive. So this webinar would be in three parts. The first would be discussion about what is justice, which will go for 15 minutes. Then after 15 minutes, we will open this forum for questions. So you can ask questions on that particular segment. Then we'll move to the next segment that would be for what is the constitutional vision of justice. That would be detailed for 20 minutes, after which we'll have questions pertaining to that segment. And the third one which will be on what is the best judicial methodology to secure justice. That will again for 20 minutes. And then we can have questions for that particular thing. In the last, we can also club the questions and have the questions together as well. I think without any further ado, I would request Sudhakar Yelagra sir to please welcome Dr. Mohan Gopal sir and then start the session. Sir.
A very good afternoon to Dr. Mohan Gopal sir, and welcome to the Maharashtra Judicial Academy. And it's my pleasure to welcome you, sir, to the Academy for this webinar. And this is the 7th webinar, sir, we are hosting in technical collaboration with the SCC Online, the Eastern Book Company. And I welcome Honorable Chief Justices, Honorable Lordships, Honorable judges from all over India, Sri Lanka, Nepal, and Bangladesh also, who are viewing this webinar. And I will not take much time. Dr. Mohan Gopal sir, in fact, is not in need of any formal introduction. He is very well-known figure throughout the world, very eminent jurist, academician, and professor. I will give a very brief introduction. Dr. Mohan Gopal sir has a bachelor's degree in law from Delhi University, master's in law from Harvard University, and a doctorate in law. He has served the Asian Development Bank for 3 years from 1983 and in the World Bank in Washington, D.C. for 18 years from 1986. He has developed and taught courses on law and development in the Georgetown University Law Center, Washington, D.C. and at the National Law School of India, University, Bangalore. He was the director of the National Judicial Academy, India for 5 years from 2006. His main area of work is the institutional framework for law and justice. He worked in the field of law and development for the last 25 years. He has served as a member of the NCMS, that is National Court Management Systems Committee of the Supreme Court of India. In fact, I can give more details, but sir does not require more details. Many of the judges have attended his sessions. He has given many lectures and he has enlightened most of us. And in the beginning itself, I welcome and thank you, sir, for accepting our request in a short time and request you to start the session. Thank you, sir.
Thank you, sir. Thank you very much for the very kind introduction. And I'd like to say good evening to all the honorable judges. I'm sorry I'm not able to be at the Academy physically. I should start by saying I'm not wearing a mask because I'm alone in this room. And that's why I'm not wearing a mask. If not, I should be wearing a mask and it makes it easier for me to speak. And I'd like to thank and compliment the Maharashtra Judicial Academy and the Bombay High Court and the honorable judges in charge of the Academy and Mr. Yeralagada for this remarkable initiative in organizing these webinars to access honorable judges from across the country. So it's a great privilege and an honor to be here. I have, for the last over 15 years, been working very closely with the Judicial Academy and basically actually learning a lot from judges about our judicial system and working very much to try to strengthen it. And I'm very glad to say that over these 15, 16 years, there have been in many areas, especially on infrastructure and judge strength and so on, a lot of improvement, mainly because of the kind of discussions and work that has been taking place in the judicial academies. Let me turn straight away to the topic, because it is a very good example of how I have been given an education by honorable judges from across the country. And that is that we know the question, what is justice, can be a very theoretical and very, very complex question. And perhaps there are a few topics on which more books have been written by jurists, philosophers, sociologists, economists, political scientists than on justice. And when at the beginning I used to ask myself, we are at the Judicial Academy and we are dealing with judges. Many judges are carrying the name justice in front of their name, not only when they are judges, but afterwards, not as a matter of right, but as a matter of regard. So we have to start by asking what is justice. So when I started reflecting on it, I realized that much of these discussions were, need to be much more focused to be of relevance to judges. And therefore, I have developed an approach to discussing this issue of justice in a way that is relevant only to judges and lawyers and all of us working in the legal field, which need not take into account or takes into account but need not repeat the complexity of this question beyond the legal field, which is real and must be recognized. But at the same time, we need to have a practical way of understanding what is justice, because like doctor must know what is the definition of health and must have a working understanding of what is good health, which is also a very complex topic. But the doctor must be able to understand, is my treatment resulting in improvement of health? So must have some kind of concept of what is health. Is it improving or not? If every single doctor had his own subjective understanding of what is good health, then it would be a big problem. Similarly, I feel very much that there must be a common understanding of what is justice, an approach, not an understanding, but an understanding about how to approach the question, so that we can have a common way of understanding whether we are making progress towards it or not. And over these 15 years, what my effort has been is to facilitate a discussion about this amongst judges and the legal fraternity, so that judges themselves, through this discussion, can gradually evolve an approach that through their own thinking and their own practice that comes from them and it does not come from anywhere else. So with this background, I want to start this process of reflection. And the reason I'm starting with reflection just is to say that, it was once said, by 3 methods we learn. The first method is by reflection, which is the most noble way. Learn by reflection, by thinking ourselves, by self-reflection. Second, by imitation, which is the easiest way if you want to learn something, but you don't really understand it. And third, by experience, which is the most bitter way. This was a saying by Confucius, the great Chinese philosopher who was contemporaneous almost with our Lord Buddha. My own view is that all 3 are necessary. You need reflection, you need imitation, you need experience, and all are useful, and that's how life is. But the job of the academy is to focus on reflection, because we are not the place of experience, that's a courtroom. We are not the place of imitation, because that's happens in day-to-day life, but we are a place of reflection. In fact, the word academy itself means a place of silence. And it means a place of silence because it's a place of reflection. And to say something is academic, in my view, is to say that it is a process of reflection. Sometimes people say, don't be academic in the sense of don't be theoretical, don't be irrelevant, don't be impractical. but that's not what it means. Academic means reflective. So we must reflect on life. Whether we are Pradhan Mantri or Mali or judge, we must reflect on what we do, and so that we can improve how we work and what we do. So that's the purpose of being at the academy. Now let me turn to the question. Before I enter into the question of the meaning of justice, why are we reflecting on the meaning of justice? And to me, there is one very important reason, and that is Article 39A of the Constitution sets out the mandate of the entire legal system, which includes courts, it includes the bar, it includes the system of legal education, it includes all the government officials of other branches who are involved in the legal system, and it includes law students, it includes in fact all citizens who engage with the legal system. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity. Now, promote justice, that is really the mandate of the legal system, and that is a very beautiful concept. It is including but going well beyond securing justice, delivering justice. We have to promote justice. For that, we have to understand what is this justice that we are supposed to promote. Is it just, it includes that, but is it more than simply relief in particular cases? If so, what is it? So this is why we must reflect on the meaning of justice, because justice is the central mandate of the legal system of our country under the Constitution. We'll come back to the Constitution later, but let's start with the question of justice. Now, the proposition, because time is very limited, the proposition that I'm going to make to you is a very simple one at this point. Justice is not simply the result of a court or a government decision. Justice is not the result of, is not simply a process of distribution. Justice is a standard of human conduct. It's a standard applicable to how human beings treat each other. Is it right or is it wrong? Because the only and central question that every legal system deals with is human conduct right or wrong? That is the core focus of the entire legal system. It is a system to try to move human conduct towards rightness and away from wrongness. And justice is that standard of rightness towards which all our efforts must move human conduct. And so this is the argument that I'm making, that from the point of view of the legal system, the point of view of all of us who work in the legal system, I would submit that you may consider justice as basically setting out a standard of human conduct by which we can measure human conduct and decide whether human conduct is right or wrong, and if it's wrong, what the consequences are. Now, just to explain the origin of the word justice very briefly, the root of the word justice is jus, J-U-S. It's pronounced jus. It's a use or righteous values governing human conduct. It's a Latin word, and therefore you can say justice is righteousness, it is virtue. Justitia is the Latin word for righteousness, we say justice. Justus means upright or just. In Sanskrit, we can say virtue means satgun and vice means avagun. So you can say justice is the standard of satgun. What is satgun? And refers not just to satgun on a day-to-day basis, but justice refers to what we consider as permanent, what we consider eternally correct. So when the members of the Sikh religion, our brothers and sisters in the Sikh religion, when they say Sat Shri Akal, the Akal is important. Satya and Shri are Akal. They're telling each other what is the standard of conduct, what is the truth, what is the highest level of morality that all Sikhs must observe. So they tell each other Sat Shri Akal. What a beautiful and wonderful greeting. So by justice also we mean a standard of righteousness which will stand forever, for eternity. Now the key issue is what is virtuous and who decides what is virtuous. This is the practical question that we want to get into in detail. One option is to say that everyone who has the right to decide, since we are talking at the Judicial Academy, let's say all judges have the freedom and the right to decide what is virtuous. There are now over 17,000 judges. There will be anarchy in this country. If you say all teachers can decide what is righteous and what is not righteous, there will be anarchy in this country. And therefore, we must have some broad framework for justice, within which we can have a lot of flexibility to understand the fact situation. But certain core principles of righteousness must be commonly shared, because that is in fact the foundation of every group and every society. Now, so the question is, if you want to have a core idea, a core set of principles around which we construct an idea of justice for administrative purposes, so that we can administer the legal system with some predictability, so that citizens can also know what does the legal system consider as righteous conduct, so that we can adjust our conduct according to those values rather than do something and believing it to be right and later to be found to be wrong. Or when law is made by lawmakers, the law itself can conform to society's highest values of righteousness, and so that we can ensure that law also advances righteousness rather than exists in a vacuum when law is made or declared by legislature without clarity about what is righteousness and what is not. So law sets out rights, liability and obligations. Law tells us what conduct is wrong. Justice is a standard of human conduct, ought to be promoted through law. So law is an instrument through which we can promote righteousness. It provides the purpose of law because it is a standard of human conduct, and I will argue it is for us who work in the legal system, it must be the values of the Constitution must be the basis. So the process by which law is applied by courts, guided by justice, was referred very beautifully and eloquently in the Sunil Batra 1978 August judgment by Justice Krishna Iyer as the infusion of the higher consciousness of the Constitution into the stone of law. Very beautiful description of the concept of how a court actually combines law and justice. That justice represents a higher consciousness of the Constitution, the highest levels of understanding of what is righteousness in our society, right? Very profound concept. And law can be interpreted, and one of the honorable judges years ago explained it to me. He said, suppose you have a law that says, Roko mat jane do. You can understand it as Roko mat jane do, or you can understand it as Roko mat jane do. Now, what is the basis on which an interpretation will be taken? Will it be Roko mat jane do or Roko mat jane do? And that must be informed by the higher consciousness of the Constitution, which must be infused into that statute through through various democratic processes, but certainly main amongst them is the judicial process. So we stop here. And then, Mr. Yeralakada, we can have a brief set of questions on what is justice and reflect on that, and then we move on to the second question, what is constitutional justice? So just to sum up, my argument is, for the purposes of the legal and judicial system to be of practical value to us, let us understand that justice is the set of principles on what is right conduct and what is wrong conduct. It's a standard of human conduct which we can refer to for the purposes of interpreting and applying law and judging human behavior. Let me stop here, sir, and request you to have a small discussion, and then we will resume.
Yes, sir. Thank you, sir. We have received many questions. I am just putting up one relevant question. The question is, can you please throw some light on the term ends of justice and substantial justice, often used in the court? Ends of justice and substantial justice.
Okay. So may I answer that?
Yes, sir. Yes, sir.
Yes, sir. See, if justice is a standard of human conduct, it is a set of values, it is sadgun, And once we identify what is Sadgun, what are the values, the higher consciousness of the Constitution, the values of the Constitution, the end of justice is to have a society which respects, adopts, and follows those values as extensively as possible. It will never be everyone. It may not even be the majority. But even if there's a minority of people who accept and value this conduct, that will spread. I was going to say like a virus, but maybe it's not the right word to say at this time. But it will spread like a good influence on society, and it will be passed on from generation to generation. Because ultimately, sir, the nation is only created and bound by a common and shared understanding and belief and faith in what is right and what is wrong, and what is righteous and what is not righteous. And therefore, it is the end of justice is to create a righteous society. And substantial justice is the one that will meet that end.
Sir, may I put one more question?
Yes, sir.
Sir, what are the duties of Indian citizen under the directive principles? Are they enforceable under the writ jurisdiction of the High Court or the Apex Court?
Sir, are the duties of a citizen? So, sir, can we postpone this question, sir?
Yes,
because
sir,
I
yes,
will be talking about rights and duties a little bit later. Now,
yes,
let us focus on any questions on what is justice.
So one question is, how far the preamble of Constitution sets out the vision of justice?
Yes, sir. That is the next topic, sir, constitutional justice. So we will deal with it immediately now. As soon as you switch me to topic number 2, I mean the question number 2.
Yes, sir. Most of the questions are on the next point, sir.
Okay, sir. So shall we move to the next question, sir?
Yes, sir. Yes, sir.
With your permission, sir.
Yes, sir. Thank you, sir. Sure, sir.
Yes. So the answer to the question you have is, let's find it by looking for standards of human conduct set out in the Constitution. And obviously, the preamble sets out the values of the Constitution in a most comprehensive manner, in a succinct manner. Professor Upendra Bakshi once said, the preamble is the Constitution, the rest is a footnote. Because all of the Constitution, in one form or the other, can be found in the preamble and can be justified in the preamble. So I think a good place to look, if justice is a set of values, is a standard of human conduct, is a statement of righteousness, then let us look at the preamble to understand what does the preamble set out as the righteous behaviors or conduct for us in our country. By the way, the preamble is only 85 words. It is an extraordinarily beautiful document. And as we know, the preamble, this is just the preamble which you all know. So I'm not going to read that. You all know it better than me. This is the preamble. I'm now moving to an analysis of this preamble, searching for what kinds of values of conduct are set out in the preamble. And from the preamble, we understand, if we go back to the preamble, we understand that the first goal of the Republic to secure to all its citizens justice, social, economic, and political. So we understand that the ultimate goal of the Republic of India is to secure justice. And so let us understand that that is our goal and see what are the ways in which the preamble sets out the values that will achieve that goal. If justice is a standard of human conduct, we need to know what are the parts of that standard of human conduct that needs to be achieved, so that we know that constitutional vision of justice is achieved. Now we have what I consider 4 duties for human beings, all human beings, especially power holders: liberty, equality, dignity, and fraternity. Now I go back to the question that was asked about duties. I consider, sir, liberty, equality, dignity, and fraternity not in the in part 3 of the Constitution, they are rights, but in the preamble, they are duties. Every citizen, every human being in India must ensure that I protect the liberty of everyone else. That's my duty. In whatever capacity. I may be President of India, I may be an ordinary citizen, but all my actions I have a duty to ensure liberty of every citizen. Now, why am I saying that, sir? Because liberty, equality, dignity, and fraternity are given to me or taken away from me only by other human beings. They may act as state, they may act as company, they may act as partnership, they may act, but ultimately, sir, human beings are the only ones who are taking away or protecting, securing my liberty, equality, dignity, and fraternity. So every human being acting in every capacity has a duty under the preamble to ensure that none of my actions will take away the liberty of anyone. I will not treat anyone except as an equal. Now, liberty is the natural state in which human beings are born. Then nooses and chains are put on us. We have freedoms. Freedoms can be restrained and restricted, but liberty, if you look at the liberty mentioned, sir, in the preamble, you will see its expression, of thought, expression, belief, faith, and worship. Sir, these are the manner in which these must be protected restricted in order to protect the liberty and freedom of others is specified in part 3 of the Constitution and other parts of the Constitution. But that there is an institutional mechanism for those restrictions. But except through those institutional mechanisms of the state, permitted by the state, I have a duty as a citizen not to take away anyone else's liberty. I have a duty to treat everyone as an equal. What does equality mean, sir? Equality, in my view, simply means that everyone must be treated with the same value. Whether you're a judge of the Supreme Court or you're a magistrate, you must have the same value. Whether you're a judge of the Supreme Court or a citizen of India, your value as a human being must be the same. You should not have, unrelated to some function or some purpose approved by democratic processes, you should not have any privileges that I don't have. So equality means is recognizing that everyone has a value. And one small exercise I use to talk about equality is when I talk of equality, sir, many honorable judges and lawyers and law students have told me, look at your 5 fingers, they're not the same. There is no equality. So then I tell them, okay, what you're telling me is that one finger is more valuable than the other finger. Now, can you identify the least valuable finger on your hand so that somebody can cut it off? Then people will say, no, sir, they're all equally valuable. My hand will not be a hand unless all 5 fingers are there, big and small. They all have different functions, but they're equally valuable, equally precious, equally necessary and essential for us. None can be sacrificed. There cannot be a balancing between my first finger and my third finger so that I can cut off my third finger. So therefore, equality means accepting that every human being has value. That value may not be obvious to us because that person may not have money, may not have power, may not have wealth, may be deformed, but simply because that person is a human being, that person has value, and that value is no less, no more than any other human being. Similarly, dignity of the individuals. So this liberty, equality, dignity, and fraternity are about how individuals treat each other, sir, and then how groups treat each other. And so I cast these as duties and not as rights. The rights come later in part 3, and each one of us. Now, clearly, sir, the main duty falls on the powerful, not on the citizens. Sir. Why are we always focusing on duties of citizens? Let us first focus on the duties of the powerful. The citizen also has a duty. What is a right, sir? A right is we always talk of the duties of the citizen and duties of the poor. A right is only a duty imposed on the powerful in favor of the powerless. That's what we mean by a duty, sir. A right. A duty is always an obligation owed by the powerless to the powerful, child to the father. No rights, duty. You owe duty to your father. But the right of the child means there is a duty owed by the father to the child. So we use the word right or duty depending on which way the obligation flows. So I would say, sir, first of all, we find 4 sets of core values in the Constitution about how human beings should treat each other. And those are liberty, equality, dignity, and fraternity. And every action of the state must demonstrably protect these values. And the state has all the power of the state under the Constitution is only to protect these 4 values and nothing else. Through that, we will build a strong country, a strong society, and achieve justice. So justice is a standard of human conduct in which human beings treat each other based on liberty, equality, dignity, and fraternity in short form. Now, the Constitution also provides 5 socio-political systems and principles to ensure that such a society can be created. And one is the sovereignty of the country, so that no other country can tell us these are not the values. There are some other righteous values. For us, righteousness is liberty, equality, dignity, and fraternity. We must have the sovereignty as a nation to protect that. Socialism, not socialism defined in a Marxist way or European way. Socialism has emerged from our freedom movement, is reflected in Part 3 and Part 4 and Part 4A of the Constitution. Similarly, secularism has evolved in our own experience, as reflected in the Constitution and in many judgments and cases. Democracy, again, we have, in a sense, democracy. India is one of the countries which has had the greatest experience in mass democracy. And democracy simply means demos means common people, and kratos means power. So democracy means power must be in the hands of common people. Otherwise, there is no democracy. If the power is in the hands of the elite and you just have elections once in 5 years or 3 years or 2 years, that's only partial method to advance towards democracy. But democracy is a system where kratos, power, is in the hands of demos, common people. And republicanism, that we are a republic, which means the rest, the object, the power is in the hands of the public. A principle that the state is created by the people, not by God, not by divinity, not by a king, not by a monarch, not by a religious force, but by the people. That's what we mean by republicanism. So we have 4 duties, 4 sets of values which are cast as duties, especially of the power holders: liberty, equality, dignity, and fraternity, 4 values of righteousness, and 5 socio-political systems to achieve that. That is what we have in the Constitution. The result is the unity of the nation and the integrity of the nation. The unity and integrity of the nation has to be built only based on these 4 values and these 5 socio-political systems, not through any other means. You cannot have compelled unity. You cannot have forced integrity. You can have unity and integrity through these values in the preamble and through these systems in the preamble. This is what my argument is. Now, sir, let me stop here. And then we move to the last question. What is a judicial methodology that will secure justice? Any questions, sir? Mr. Gill, how are we doing on time? Hello? Have I lost you?
No.
Chetan, are you in time? Yes, sir.
I think we are broadly on time here. 4:30 p.m.
Sir, there are questions on this.
Yes.
Can moral values be equated with the values of justice?
Yes.
moral values can be equated with the values of justice?
Yes. Can I answer that, sir?
Yes, sir. Yes, sir. Please.
Yes. See, very good question. Can morality be justice? Can charity? What is the difference between charity and justice? What is the difference between mercy and justice? So they're all interrelated concepts. Morality refers actually in its pure sense to the way in which people actually behave, the mores of the people. Charity is what is given by our grace, by the grace of the giver, at the free will of the giver to the person who receives it. So also mercy. You cannot compel mercy. You cannot compel charity. Morality is actually the standards of behavior, the way in which people behave, what people consider right or wrong. Justice is the use, the righteousness, the standards of righteousness against which we can judge morality. Now, charity and mercy may be granted on the basis of these ideas of righteousness. But the difference between charity and mercy on one hand and justice on the other hand is charity and mercy may or may not be given by somebody. Justice has to be given by everyone, especially institutions that are responsible to give it. Justice cannot be denied. Charity can be denied.
Sir, may I pose the next question, sir?
Yes.
Sir, question is, if the justice is the standard of human conduct, then what would be the source of justice, whether it is law, religion, or anything else?
Yes, sir.
Please, sir.
Very good question, sir.
Sir.
As a concept, sir, all of these can be sources of justice. And they are sources of justice. My family is a source of the idea of justice the family is a source of the idea of justice to everyone. The local community is your larger culture, maybe your religion, maybe all of these can have beliefs in what is righteous, what is right conduct, what is wrong conduct. The question is, for the legal system, for a court of law established under the Constitution of India, for lawyers, for law students, for those who participate in the judicial process, for judges, what should be the source of the ideas of the standards of conduct? Where should they draw their norms of righteousness from? Should it be from their own personal sense of right or wrong, or should it be from the Constitution? Obviously, sir, you have to draw it from the Constitution. And if you are not prepared to draw your sense of right or wrong from the Constitution, then we are free to be outside the state system and argue that the constitutional sense of justice must be altered to make it what we want to make it. The Constitution gives us the liberty to do that, to say, let us change the Constitution and give another set of standards of conduct. But so long as the Constitution is there, all of us who work within the Constitution and who work under the Constitution must look only to the Constitution to see what are the highest values by which we must judge human conduct. And from the preamble, and if you go to part 3, part 4, part 4a, I normally go into that in detail, but now there's no time to do that. I'm just working with the preamble to define the constitutional vision of justice. But if you go to part 3, there are about 18 rights which set out the same four values of liberty, equality, fraternity, and dignity. You'll find that in part 4a. You'll find it in various other parts of the Constitution. For example, in part 3, you can find it in Article 19, in Article 20, 21, 22. 23, 24, 25, 26, 27, 28, 29, 30. All of those are based on these ideas of equality, liberty, and fraternity. So, therefore, I would say, sir, for us in the legal system, we have to find the answer to the question: where do I find my standards of conduct? Only in the Constitution, justified within the Constitution. Now, that gives us a lot of lot of rooms for interpretation, because these are very broad ideas. What are liberty? What is liberty? What is equality? What is fraternity? What is dignity? But we know what it is not. We know what it is not. It is sometimes difficult to say what it is, but you must be able to reasonably justify with reference to constitutional rights and values and laws how you arrived at that conclusion that your understanding of these values are based on constitutional law. And so so that's a different discussion. We decide to locate it in the Constitution, but then we have a discussion on how do we find it in the Constitution and what should be our discussion.
Thank you, sir. Next question is there any difference between the term freedom and liberty in relation to the constitutional values pertaining to thought, expression, belief, faith and worship? Yes, difference between freedom and liberty.
Yes, sir. It's a very excellent question. I've reflected a lot on this, and I believe that my very brief understanding for our purposes, sir, in our discussion, is that liberty, sir, is not something granted by the state. It is the liberty of the citizen from which the state itself was born. The liberty of the citizen is the uterus of the state, sir. The state is born in the liberty of the uterus. So the mother of the state, the mother of the Indian Republic, is the liberty of the citizen, of the Indians. So therefore, the liberty cannot be granted by the state, because our republic the origin of it is not in God, it is not in religion, it is not in any other power or colonial power, it is in the common people of India. So therefore, liberty is the state in which people are free, is the condition, human condition in which people are free to create a state, to create the constitution, to create courts. That's what liberty is. It's not given by anybody. And that liberty, the core of that liberty that we are recognizing, not granting, but recognizing, because the constitution is born from that liberty, is thought, thinking, expression, belief, faith and worship. All these existed because we are human beings, not because they're given to us either by religion. Religion is also the institutional structures of religion represent a relationship between human and humans. But here, when we talk of faith and worship, we are talking about relationship between human and the supernatural. And that is not created by any human agency. So therefore, liberty is the primordial state, it's a starting point. From there arises freedom. Why do we need freedom? Because that liberty is used by some human beings to take away the liberty of others, to impose restrictions on liberty. Freedom gives us the right against those restrictions on liberty, so that we can maintain our liberty through our rights to freedom. So freedom, the right to freedom is created out of liberty through the state, defined by the state according to its institutional framework, and we can access those rights of freedom, which are, as you know, sir, is set out in Article 19 of the Constitution, and it includes speech and expression. So speech is not in the preamble under liberty, expression is, and to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of India, to practice any profession or to carry on any occupation, trade or business. These freedoms arise from our liberty. They are not a complete and exhaustive description of our liberty, but maybe these are areas where there is maximum restraint being put, or the need to restrain in the interest of liberty. So we have identified the areas where there is a controversy about restraints on liberty, and that is what we have put under the right to freedom, so that we can use those rights to both protect our liberty and also sometimes to come to reasonable conclusions on what kind of restrictions are necessary on liberty to protect everybody's liberty. But inherently, sir, both these words are, I don't think they're materially different. As words, they're not, or concept, they're not materially different. But their constitutional usage is different. And we must understand the status of liberty, sir, as the mother of the Republic and the mother of the Constitution, the liberty of the individual Indian citizen. Sir.
So thank you, sir. Before going to the other topic, one question is there. Sometimes we judges use the phrase "for the sake of justice," and sometimes we use "for the ends of justice." The question is, are they same or different?
Sir, I think those two words that are some. One comment I have is that sometimes, see, as you know, sir, much better than me, you're very senior judge. Under CPC, CRPC, and all that, the judgment is supposed to give the grounds and reasons for a decision of a court. Right or wrong, sir? Correct? Sir. Am I right, sir?
Yes, sir. Yes.
Therefore, we have to give specific reasons. Now, I sometimes find, sir, when the specific reasons are not easily available, then some courts say it, in the interest of justice or for the ends of justice.
Yes.
But so what we need is, sir, for courts to say what exactly are they meaning when they say ends of justice or interest of justice. What is it for liberty? Is it to protect liberty? Is it to protect fraternity? Is it to protect dignity? Is it to protect equality? And in what way? Because that is the framework of justice. That is the constitutional framework of justice. So how are you in this particular case in front of me? And now we are going ahead to the next topic. In this particular case in front of me, how are we going to come to, how am I using my power to advance the standard of conduct of human beings to each other laid out in the Constitution, namely, human beings should have a duty to protect everybody's freedom and liberty, and to protect everyone's equality, protect everyone's fraternity, and protect everyone's dignity. And how is my decision going to advance those values of human conduct is something that court should clarify. So I think these phrases are used sometimes when the reasoning is not fully stated in the judgment by the court.
Sir, so a small question, sir. What is the difference between justice and justice according to law? And again, whether both are equal to natural justice?
Yes, sir. Sir, as I mentioned earlier, sir, the natural justice. Let's start with that, sir. Natural justice is an explanation about the source of justice. Where does the idea of justice, namely that human beings must behave to each other in accordance with certain approved norms? That is the idea of justice. That is part of every human being's mind, sir. Even a 5-year-old child, if you take a piece of chocolate and break it into 2 unequal halves and give a smaller half to the child will say, no, that's not the right conduct. I must get half of it, not a smaller half. So every human being, and also some other species, sir, we have experiments to show other species also react to what they consider as not rightful conduct. They don't like it. So all sentient beings have not, perhaps most, certainly human beings and certainly many other sentient beings we know have a sense of what is right conduct and what is wrong conduct. And when we say natural justice, we mean that a mere sense that there must be right conduct. But we do not go to the next step, sir, saying what exactly is right conduct. That is, natural justice does not give us that answer. So that answer has to come to us from a constitutional document, written or unwritten, or some kind of political document created by society on the basis of which a nation is created. That says, okay, everybody wants natural justice, but what do we mean by justice? So we have a constitution which says very simply that justice means a standard of conduct where every person protects every other person's freedom, liberty, equality, and dignity. And a methodology to do that. But it requires also, sir, that my liberty is not taken away by somebody else's liberty. My equality is not taken away by somebody else's equality, and so on and so forth. And therefore, there must be a method by which we determine whether or not somebody's liberty, a question of liberty is involved, whether a restraint is being put in the interest of the liberty of that person and others or not. And that is where law gives us rules of conduct. So law prohibits in advance, for example, murder. Now, sir, according to me, sir, law is only a hypothetical fact pattern. Every law sets out a hypothetical fact pattern. So take murder. With intent to kill, you shall not commit an act which results in the death of somebody else. That's a hypothetical fact pattern. So in order to protect liberty, we have set out a hypothetical fact pattern saying that you shall not either do it or attempt to do an act intentionally to take somebody else's life. That's a hypothetical fact pattern. So we know in advance that if that hypothetical fact pattern arises, somebody's liberty has been totally removed, his life has been taken away, or his liberty has been severely curtailed if it's an attempt, unsuccessful attempt. And therefore we know that that kind of loss of liberty has to be dealt with through the Indian Penal Code framework for trial and punishment, conviction and punishment of murder. So we have to do justice through the legal provisions and frameworks prescribed to protect these four values. But we have to use these provisions. As I said earlier, sir, law is a tool of justice. We have to use these provisions to advance and not to defeat or weaken these four values that constitute justice: liberty, equality, dignity, and fraternity. These four values have to be protected and safeguarded. That is the purpose of law. But law is the method through which we safeguard this. If not, there will be anarchy, there will be arbitrariness. And arbitrariness itself is a form of injustice, because somebody is arbitrarily getting the benefit of the protection of his liberty, but somebody else whose liberty is curtailed is not getting that protection. To avoid all these complications, we have developed the legal system and the judicial system and the court system and many other systems, the executive systems, legislative systems, in order to ensure that these four values are protected in a fair way, in a systematic way, in a methodical way. And therefore we say that these four values that constitute justice should be advanced through the law, in accordance with the law. And where the law is new or does not exist on a particular question of justice, there the legislature, like for example on sexual harassment, Vishakha, the courts came in and said, okay, the dignity and liberty and equality and fraternity of women are being violated in the workplace. And therefore the Supreme Court stepped in, Chief Justice J.S. Verma, and he wrote a judgment saying this is a method by which we should protect the justice for women, namely these three values, four values. And that was then laid down. Later it became a legislative act, and that act has also come into place. So where the law doesn't exist, demonstrably, and if you read the Vishakha judgment, you can see Justice Verma referring to national and international documents to the Constitution, explicitly saying that this intervention is necessary because there is an area in which liberty, equality, fraternity and dignity of women are being violated and there is no law to protect them. Therefore, we have to create the law, because we cannot let injustice flourish because there is no law. So when there is law, it must be used. When there is no law, there are methods by which legal rules can be established through legislative interventions and through judicial interpretation of existing law, and to protect the values of justice.
Sir, before starting the next point, I have three relevant questions, sir, which sir you can cover in that.
Yes, sir.
Please throw some light on the social context justice also. That is one request, sir. And second is, normally we hear justice should not only be done but also seen to be done. What are the broad parameters? And the third one is, sir, please throw some light on Indian constitutionalism and modes to achieve justice in India. Our topic next point is, yes, sir.
Yes, that last one we can take up next topic, sir. Modes to secure justice. Last one.
Yes.
If you agree, sir. So,
Yes, sir.
what is the first one, sir? I just repeat.
Can you elaborate the social context justice?
Yes, sir. Yes, sir. Let me finish that, and then you can kindly remind me of the other.
Yes.
The other.
Yes.
Sir, social context justice is a very, very excellent question, sir, because there is something unique about the Indian Constitution, sir. That what is unique about the Indian Constitution, in the Constituent Assembly, in our freedom struggle, and in the actual Constitution, is a very important objective to bring about social change, to address huge social inequalities and poverty in our country, sir. Inequalities, inequities, and poverty. That is why Article 38 of the Constitution says, sir, the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order, not an economic order, not a political order, by securing and protecting a social order in which justice, social, economic, and political shall inform all institutions of national life. Therefore, see, why did India get conquered, divided, impoverished, so many people suffering? So the idea was that we need a social order in which justice, social, economic, and political inform all institutions of national life. This was the aim of the masses of India in participating in our freedom struggle, sir, which ultimately was their struggle, sir. We had many prominent leaders, but the struggle was the struggle of the masses, sir. And so they wanted a new social order in which they have these values of equality, liberty, fraternity, and dignity. Now, how do we bring about change in the social order, sir? Changing social order is social justice, sir. Is creating a just social order, democratizing our society where it needs to be democratized. And so when we talk of social context judging, is taking into account the social realities within which human conduct relationships are taking place. So is there real equality? Even if on the paper there is equality, is there real equality between man and woman? Between superior, socially superior and socially inferior, between rich and poor. And so so that we don't look at the facts that we take into account must also include social facts and not simply the facts that are produced without reference to the social reality and context. But the procedure is the same, sir. We have to take cognizance either through judicial notice or through evidence. And there's a wonderful example, sir. Vadekar, sir, Kailash Vadekar judgment of the which I use in many sessions in the judicial academies all across the country, sir, where Maharashtra judge, district judiciary judge, gave a wonderful judgment, sir, which I use, and it's one of the fine examples, sir, where the question was an SC/ST atrocity was done against a tribal woman, and when the trial came, the powerful people in the system, in the community, ensured that a certificate of tribal certificate, ST certificate, was not issued to this woman. So the defense said that she is not a tribal because she does not have a certificate saying she's a member, she's a tribal from the Bhil community. This judge wrote a wonderful judgment, sir, which got that part of the judgment was upheld ultimately by the Supreme Court, although I'm not getting into details of that, but that part of the judgment was upheld by the Supreme Court also, where the judge said, look, women are punished and humiliated in many ways in our country. I'm not quoting him, the gist of what he said. Punished in many ways in this country, and but how a woman is punished depends on her social status and her social background. Now, this woman was stripped, beaten, paraded through the village without any clothes while being beaten. He said, this is a type of punishment reserved for scheduled tribe women. I don't need any proof that I don't need any certificate that she's from the scheduled tribe, because she would not be punished in this manner unless she was SC/ST. He recorded that as a finding. He convicted on that. On the High Court, they found that the investigation was done on, and the High Court did not accept this reasoning and reversed the conviction because the investigation was done by officer below rank of DYSP and there was no certificate. But the Supreme Court, sir, wrote a judgment in which they said the High Court's reversal was on hyper-technical grounds. And basically said, but they could not set aside the High Court judgment because the appeal was only, there was no appeal against the SC/ST Act acquittal before the Supreme Court. It was only the IPC conviction against which the appeal came to the Supreme Court. So the Supreme Court did not reverse that. But the Supreme Court set up de facto disagreed with the High Court's reversal of the SC/ST conviction by referring to it as on hyper-technical grounds. That's not a real reversal, but it is more a comment rather than a reversal. I should correct myself. But so here is an example of a judge looking at a social fact. Which community women are stripped, paraded, beaten? And from that, can you draw a conclusion? That not necessarily, that others may also be subjected to this view. And if there is some evidence being led on that, sure, he should consider that. But under all the evidence before him, all the circumstances of the court, he found this. And the only response, even in the High Court and by the defense, was no certificate. They did not say, the High Court did not say that this finding was wrong. So this is one example, sir. There are many other examples of how it's a challenge, sir, to our judicial methodology. I would suggest that if this is done, maybe some expert evidence can be led by some sociological experts, so that the judge is not coming to the conclusion, but the judge has evidence before it. So the defense can also question. If the judge says, okay, only tribal women are punished this way, let a sociologist come, give evidence, let the other side have a chance to contradict, cross-examine, bring their own expert, then the judge can make up their mind. But these are examples of social facts. I'm not saying the methodology is necessarily correct. I'm also not justifying one for a decision or the other. But I'm simply pointing out the importance of opening up to the social context and reality in an appropriate way, consistent with the Evidence Act and consistent with the Criminal Procedure Code and other applicable rules.
So
second point.
Yes, sir.
Yes.
Second is justice should not only be done but also seen to be done. What are the broad principles?
Yeah. Yes, sir. So there, I think, sir, it is the transparency of the process. Sir. Transparency of public. We want public justice, open courts. There, people must be able to see the process. People must be able to understand the reasoning of the courts. What are the principles on which the courts operate? Why are they making their decisions? Because it is the people, sir. These are the power, and sir, in the objectives resolution of the Constituent Assembly, there is a statement: all power and authority of all the constituent organs of independent India shall come from the people. So people have to know, is the power that we have given to the courts being properly utilized or not? It is not a feudal system where there is power and you can exercise it and there is no answerability to the people. So it must be seen to be done. Secondly, one other aspect of it is that it must be done in a way that is conforms to these principles, sir, of liberty, equality, dignity, fraternity, and implicit in that also, sir, the ideas of rule of law, of fairness, and other elements of justice which we take for granted, sir. That everyone, especially the idea of fairness, which, as you know well, sir, is popularized by John Rawls, the idea of justice as fairness. That's also a very important idea that the judicial system cannot ignore. But in my view, that is very much implicit in equality. You cannot have equality or liberty without fairness. Without fairness, you'll have arbitrariness. So it's a detail of that higher level value of equality and liberty, but that's also important, sir.
So can we move to many questions are pertaining to the next topic, sir? We will cover.
Yes.
That.
So let us move to the next topic, sir. I think We are roughly on time, I think, no? 5 minutes later. So, yeah. Now, usually, any judge, any case in many things in life, but let's talk only about a case before a court, involves an interplay between facts, law, and moral judgment. So you want to know what happened. Evidence Act tells you how to determine that. Then there's the law. The law lays down, as I said, hypothetical facts, fact pattern, and you want to see whether the facts actually show that the hypothetical fact pattern, which is prohibited, has occurred or not, and then there is a consequence. There's also the area of moral judgment. Usually we use, Mr. Yeralakada sir, you refer to the word moral. So moral means basically some sense of right or wrong, which is in the community and in the judge and in the lawyer and in the parties to the case, and everyone has. That's what we mean by morality. It is a populous idea of what is right or wrong. Of course, you can. Dr. Ambedkar has given us a long speech on lecture on constitutional morality. Our Honorable Supreme Court has also talked about constitutional morality. So morality can also be at a higher level. But at an individual level, community level, there's moral judgment. So let me now, based on that, sir, the normal way which I have learned from judges about how you make a decision, sir, is first we look at the facts in a case. And then we say, immediately when we look at a set of facts, sir, we automatically come to a consciously or subconsciously, we come to a personal moral judgment about what did somebody do something wrong. That's human. It may not be based on law at all. It may be based on law for somebody educated and trained in law. But every human being, when they see a fact pattern, they will have a moral judgment on it, if there is a moral issue. Now, very often what we do, not just judges, but many people, like say vice chancellors and other authorities, executive decision makers, including judges, decision makers, they will test this moral judgment against the law and say, okay, I have a moral judgment, okay, let's say a man threw out his old mother from the house in the middle of COVID. This is a fact pattern. Immediate moral judgment, that's wrong. Old lady has been thrown out of the house because of suspicion that she has COVID. Actually, let's say she does not have it. Somebody threw her out. So you got a moral judgment. Then we test that moral judgment against the law. Is she required to be admitted in a hospital? Can she stay in the house or not? So what is the law? But we already think that it's a wrong thing to do. And I'm not saying that's wrong, but that's inevitable in the way we function. Then but our back of our mind, we want to see how we can use the law to keep her inside the house. We don't want her to be destitute. So we evaluate statutory provisions and judicial precedent to see whether we can find some law to ensure that we can keep her in the house and support our own moral judgment. Then we form a legal judgment that will support our moral judgment. Sometimes we say that we cannot find the law, then we say that, like many people say, many lawyers say, some judges say, that we have to go beyond the law to do justice, because by justice they mean their own personal moral judgment. And the law becomes a barrier to implement that moral judgment. And then you write the judgment, issues facts, law, decision. So this is the traditional way. Now, where is the room for securing justice or constitutional vision of justice that we talked about in the last few minutes? That is the question. So for that, sir, this is a moral method. Who is right? What is right? And so justice actually is there, but it is very personal to the people involved in that case. It may be a powerful lawyer, it may be a powerful litigant, it may be a witness, it may be a judge, but some people with strong moral sense are able to selectively present the facts in such a way that a moral judgment will follow and a legal judgment hopefully will also follow. There's another way, sir, which I call normative method, which gives centrality to justice. And what is that, sir? First of all, sir, I would say look at the relief that is asked for in the case and identify the right, liability or disability under law that is asserted or denied in the proceedings. Why do I use this word right, liability or disability, sir? Because it is the basis of the evidence of the definition of facts in issue and relevant facts in the Evidence Act. Because you know that all courts from the trial level to Supreme Court can only act based on facts. Facts facts in issue and relevant facts can be admitted before a court. And therefore, the entire decision is based on fact in issue and relevant fact. What is the definition of fact in issue? It's basically about the existence, non-existence, nature or extent of right, liability or disability. So you can only come to a court to assert the existence, non-existence, nature or extent of right, liability or disability that is asserted or denied in the proceedings. So then once you identify, so in this case, let us say the right of this woman, this old lady being asserted is that I want to stay in my house. I don't want to be thrown out. So identify the legal standard required for the assertion or denial to succeed. So let us say that the prayer is being brought on the basis of let's say the Prevention of Domestic Violence Against Women Act, the right to residence of the woman. So you have said, okay, you're now not looking at the facts. You don't know it's an old lady, you don't know it's been thrown out of COVID, son, nothing. You're looking at the relief sought, and that relief sought is that I want the relief of being able to stay in a house. Under what law? Under Protection of Women Against Domestic Violence Act. Then ask yourself, what are the elements of that law, that hypothetical fact pattern that needs to be satisfied for this relief to be given? Identify, so you understand that. Next step, sir, is actually one again, that's a mistake, but it should be two. But I will just repeat, I will use the one so that it's not confusing. Then, sir, at that stage, the judge or the decision maker or the lawyer on the parties, because it's everybody's duty to uphold justice, should, in my view, in my suggestion, identify the constitutionally authorized norm underlying the law. So, Protection of Women Against Domestic Violence Act. Underlying that norm is what? It is dignity, it is equality, it is fraternity, it is liberty. So it is to protect all these core values that we have a law called Protection of Women Against Domestic Violence Act, so that inside the house, these values can be protected. So now you know that you know the Protection of Women Against Domestic Violence Act has a requirement to get a right of residence. I'm not getting into that in detail. But you also know now that the constitutional values to be followed here, the justice constitutional standard of conduct which constitutes justice to be followed here is at a high level, very intense level, because all four values are involved in this act. So you know that this fact pattern has to be interpreted to uphold the liberty, equality, dignity, and fraternity, especially liberty, equality, and dignity of the woman. So then keeping that in mind, you look at the facts in issue, determine whether there are any alleged facts or facts in issue or relevant facts from which the existence, non-existence, nature or extent of such right, liability, and disability necessarily arises, right? So I identify whether what are the facts in support of the right to residence, and what is proved, what is not proved, and then identify the issues for determination, because issue may be to establish some evidence that the hypothetical fact pattern required for a right of residence is proved or not, and formulate the issues to determine whether she has a right to residence or not, get the proof of facts, and you get a legal consequence. So if she satisfies all that, then she gets a right to residence. And that right to residence she must get in order to uphold her equality, her dignity, and her liberty. And by then you will be able to see whether there are any other reasons or other factors. If I simply say son and mother, then the whole moral judgment gets colored. But are there any other facts to show that actually these issues of equality, dignity, liberty, justice issues are not involved in this particular case? I'm not getting into detail for lack of time, but you all know, honorable judges watching or seeing, many potential fact patterns where you can't assume. One very senior judge who was a judge of the High Court, then went to the Supreme Court, retired from the Supreme Court. He was telling me about how he once granted custody of a girl child to a mother, and the girl child was not prepared to go with the mother, was crying and screaming, and so he, the mother's lawyer said that there's something wrong with the child. So in order not to single out the child, he ordered a psychiatric evaluation of mother and daughter and father. And when the report came, he found that the mother was a very respected professional in that place, but was actually a schizophrenic, and the child was afraid of her. So he said, I had quickly recalled my order and withdrew that order and gave custody to the other parent. Now, because you assume in a fact pattern that the girl child mother custody must go to the mother, but actually you have to look at what are the interests being protected here. What are my obligations? So at that point here, to protect actually the life and liberty of the child had to be protected. And for that, you can't assume that the child, because she's a girl child, must just go to the mother and therefore everything is fine. So you must make sure that the facts are in front of you, and you are examining what are the relevant facts to protect these values, and then come up with a decision. And that is what I mean by the constitutional vision of justice, and by delivering or securing the constitutional vision of justice is through this through a procedure which does not allow you to be your moral judgment to dominate, but allows you a process of methodology that allows a due consideration of the impact of your decision on protecting and advancing these constitutional values in a conscious, fact-based, law-based manner and effective manner. Now, Justice Krishna Iyer, sir, another wonderful quote from him, he described social justice, goes back to the question you raised, is finding procedures which are conducive to the pursuit and protection of the rights of ordinary people. Now, please note that Justice Krishna did not say protecting the rights of ordinary people is social justice for a court. No, it is finding the legal procedures, the law, the principles which are conducive to the pursuit and protection of the rights of ordinary people. So when you read all the judgments of Krishna Iyer, Ratlam municipality, all his public interest litigation, you will find that they're all solidly based on law and legal analysis. And he does not fall back upon plenary rights, saying I can simply go, I'm a judge, I will protect the rights of ordinary people in my own way. You have to go through the path of law and legal procedure to do that. Finding that is social justice for the court and for a judge, according to Justice Krishna Iyer. And that is a challenge where the academy can help, all of us can help, work together by pointing out that there are tools and ways in the law by which you can advance these values of the Constitution, as Justice Krishna Iyer did in his time, and many other judges have done. That judge in Maharashtra did in that case that I referred to wonderfully, and Justice Dev in Bhopal, District Court judge, did in the Bhopal gas tragedy case. Recently, when the gas leak took place in Visakhapatnam, I was thinking of Justice Dev, because Judge Dev, as a district judge, laid down the principle that interim compensation should be paid by the company responsible for the injury, even if before any fault has been found. And when this company argued that they should not be asked to pay, then it was just Mr. Dev's logic that overruled, and the court and the public and everybody said, no, you have to pay interim compensation to people who were injured. So the power of judges and I would encourage all the judges. It's available on the net, including, I hope, on the National Judicial Academy website. The wonderful judgment of Mr. Dev as District Judge of Bhopal where he argues the law, he found the procedures conducive to the pursuit and protection of the rights of ordinary people. A living example of a person who realized and protected the constitutional vision of justice is Mr. Dev, whose picture in the National Judicial Academy is the only non-ex officio picture in the entire National Judicial Academy of a district judge of Madhya Pradesh. Let me stop here, sir. Any other question?
Yelena, sir, your mic is muted. You have to unmute your mic. We couldn't hear you, sorry.
Sir, thank you, sir. How
Yes,
do we remove the general perception that constitutional rights of citizens are meant to be protected by the constitutional courts?
Sir, again, a wonderful question. Sir, I've now forgotten the count, but around, forgotten means just slipped my mind, around 32, 33 times, sir, in the Indian Penal Code. If the ordinary criminal trial courts, magistrates courts, the sessions courts are referred to as courts of justice in the Indian Penal Code as courts of justice. So every court is a court of justice. Now, justice for a court is only constitutional justice, not personal justice. Constitutional justice. And I am arguing today that that idea of constitutional justice must be on 4 legs, only 4 legs: liberty, equality, fraternity, dignity. And everything, all decisions advancing justice must be explainable or accountable to these 4 legs of justice. And that gives massive canvas, sir, massive canvas, because these are such powerful and infinitely, infinite ideas. So every court is a court of justice. Justice is only constitutional justice. Now, last point. Every court has jurisdiction and set of powers unique to that court. So you will remember, sir, Justice R.V. Ravindran of the Supreme Court used to always tell judges in the academy, regardless of whether they were magistrates, ADJs, session judges, High Court judges, Supreme Court judges, he used to tell the district judiciary, you are judges, you are a judge, I am a judge. There are certain things you can do, I cannot do. There are certain things I can do, you cannot do. So there are differences in jurisdiction and powers. A Supreme Court cannot commit a case to sessions, a magistrate can, and so on and so forth. So now the question, sir, is how can we use, like Mr. Dev did, sir, District Judge of Bhopal, how can we use the powers of every court, whether it is the Supreme Court or Magistrates Court, working within its powers, within the law, within the jurisdiction, to advance these 4 principles that constitute the constitutional vision of justice? The 4 principles, the 4 duties, the liberty, equality, fraternity, and dignity. Now, there's a lot of scope to do that, sir. Justice S.B. Sinha, sir, God bless his soul. He passed away, we've lost him. He is one of the greatest contributors to judicial education in our country, sir. He sacrificed so much time and effort to build up the judicial education in the country. He used to always detail from the CPC the various kinds of provisions that are there that correspond to the writ jurisdiction of the High Courts and Supreme Court. So, have we exhausted all the powers that all the courts have to protect and advance and secure constitutional justice? I don't think so, sir. I think there's much power remaining to be used. Are there cases where, if under Article 32, writ jurisdiction of the Supreme Court was also vested in subordinate courts, are there some instances where they could do something that they now cannot do? Yes, I would say yes, that is correct. And maybe that can be done. But I think, sir, the idea is not to have more power, but to see how, first of all, to use whatever power that we have, can we use it effectively or not? So for the last 10, 15 years, sir, I've been working with the judicial education. I have absolutely no power except to reflect and engage in discussions like this. But I feel I can do much more than I'm doing. I am far from exhausting my powerlessness before I want any power. So let us try to use the power we have, but I certainly think, sir, that the courts at the frontline courts should be fully and adequately empowered to protect and secure these values at the local level. There I'm very clear, and I see no difference in the constitutional responsibilities of the district judiciary and the high courts and the Supreme Courts, for one reason also, sir. The 1935 Act, Government of India Act, under the judiciary only had the federal court and the high courts. Subordinate courts were under the executive branch. The 1950 Constitution has transferred the subordinate courts to the judiciary. And therefore, sir, subordinate courts are also constitutional courts. Their power is not set out in the Constitution, their jurisdiction is not set out in the Constitution, that is set out statutorily, but they are constitutional courts. The positions of district judges are, as you know, sir, your position is referred to in the Constitution. So this country cannot abolish district judiciary without amending the Constitution. Therefore, all these courts have in my view, are constitutional courts. Do you have powers directly vested by the Constitution? No. Does the Constitution envisage that? Yes, in Article 32. Has it been done? No. But I don't see a big difference in the status of courts as far as the responsibility is concerned to protect constitutional rights.
Sir, I'm very glad to say, sir, from the Nepal Judicial Academy, Dr. Diwakar Bhatta is also connected. He is also attending the seminar, and he thanked you. And sir, a question from him is that, as you said, sir, justice is eternal values and standard value for human. Then why the laws are standard value for human? Justice is eternal. Yes, sir. And why the laws are changed? Pardon, sir.
Sorry. Laws are?
The justice is eternal values and
yes,
standard
sir.
Value for human.
Yes, sir.
Then why the laws are changing and different decisions are made in different times? Can you reflect on this?
Yes, sir. Yes, sir. Very, very good question. Thank you, sir, for joining this program, and thank you, sir, for your wonderful question. Our honorable judge from Nepal, very honored to have you, sir. Sir, I think first of all, see, it is because decisions and laws and interpretation are changing that we need the constant North Star of justice as a set of eternal values. In our Constitution, 4 eternal values: liberty, equality, fraternity, and dignity. These are eternal values, should never change. So when laws change, decisions change, we have to test them. Are those changes advancing these values or deviating from those values? If they are deviating from those values, they must be brought back. But if they're further advancing and broadening those values, that's a good thing. So, for example, sir, A.K. Gopalan versus R.C. Cooper, right? Where initially the Supreme Court took the view that each of these fundamental rights are separate and not correlated. And if you're seeking relief under one, then you cannot get relief under the other, and so on. That kind of segmented approach is now gone, sir. And now we have recognized the indivisibility and the interrelatedness of all these rights. That's a good thing. That's a good change because it helps us to protect these 4 values more. Similarly, sir, the various interpretations to Article 21 of our Constitution on the right to life and personal liberty, where we have brought in environment, food, and various education into we have given life to the judicial interpretation has given life to the right to life by broadening it. Those are good changes that have given greater protection to these 4 values that constitute justice. So we can see good changes, and similarly we can see some ADM Jabalpur has been overruled. but some of the judgments by which it was overruled, including Justice Dhananjay Chandrachud from Maharashtra, Bombay High Court, who now in the Supreme Court, a senior judge of the Supreme Court, who overruled the ADM Jabalpur and wrote wonderful judgments in many cases, including in Puttaswamy, on privacy. These are positive changes. So I hope we can all work together to ensure that with this guidance of these 4 values, as the substance of justice, as the content of justice, and the essence of justice, we can move forward to strengthen these 4 values for the poorest people, the commonest people of our country, sir, who are the authors of the Constitution, whose liberty has created the Constitution, and it is whose liberty that gives you power, sir, as judges. It is the liberty of the common people that has created the Constitution that then gives you power to be judges. And so let us use these values, give it back to them, and protect their liberty, equality, dignity, and fraternity, sir.
Sir, with your permission, I would like to share a very small incident to quote the relevance of the subordinate judiciary in the Constitution. In my first training at the academy, discussion was going on this role of the subordinate judiciary, and some senior judge said that to the magistrates, we are subordinate judiciary, you are not constitutional authorities. But one batchmate who practiced on constitution side before becoming a JMFC said that, sir, the High Courts and Supreme Courts come very later on, and magistrate comes first in Article 22, Clause 2. He said that it is the magistrate who also comes in the enforcement of the fundamental rights. Sir, sir, am I audible, sir?
Yes.
Sir,
I can hear you.
Sir, in this context, sir, on civil side, the question is, sir, can you elaborate on the situations where the civil courts, by issuing mandatory injunction, can address the violation of constitutional rights?
Sir, you can answer this better than that. I think all powers available and justifiable under the law must be used, sir. And Ratlam municipality was a classic example, sir, of an executive magistrate using his powers to give mandatory injunction to clean up Ratlam in Maharashtra. No, he's in Madhya Pradesh, not in Maharashtra. Near the Ratlam in Madhya Pradesh, and which then became the whole basis of public interest litigation, sir. So yes, absolutely, sir. You know better than me. But I think power has to be used, as you said, sir, in a justifiable way, legal way. But the objective must be to uphold constitutional rights, and certainly mandatory injunctions where permissible should be used, sir, and can be used to protect. Ultimately, the judiciary, may I just say, sir, that Justice P.D. Desai from Gujarat, who was the chairman of was the judge of the Supreme Court and chairman of the Law Commission, as chairman of the Law Commission, wrote the 117th report of the Law Commission of India on judicial training, where he has wonderfully said, sir, that overnight in 1947 and 1950, the judiciary of India's role was transformed from being extension of the law and order machinery under the colonial government to being sentinels on the qui vive, sentinels on the alert, sentinels, guardians of our fundamental rights. And that this was an enormous transition. And therefore, he recommended that academy should be established to bring about this change, sir, from colonial court to constitutional court, colonial role to constitutional role, protecting the powerful from the powerless to protecting the powerless from the powerful, to being an arm of the state, to being a guardian of the people, to ensure that the state power, that's you had asked a question of constitutionalism. Constitutionalism is the idea of limited power. And who limits the power? So only the judiciary has the capacity to limit state power. I cannot limit state power. I can complain, but only judiciary can limit state power. So therefore, this transition, sir, from a authoritarian colonial judiciary to a democratic Republican judiciary is a very important transition, that must be made, and that is why we have academies. That's why we have this discussion. And so all power should be used always to protect these core constitutional values and the idea of constitutional justice.
Sir, we have discussed, referred to the cases of Ratlam municipality and the judgment of Honorable Chief Justice Dev in the Bhopal gas case. We judges will definitely reflect on that. But sir, you can enlighten on the question, why we do not find the orders such as one in the Ratlam municipality case and that Bhopal gas case?
Sir, I think these. I think the orders are there. Maybe we are not aware of them. For example, the Kailash Wadekar case or the Ram Lakhan case in Delhi, sir. The Delhi High Court judgment of Justice Bhagat Dores Ahmed. I have spoken about it all over the country for many years. This Kailash Wadekar case. There are plenty of cases where wonderful judgments are being given at the local level. I think we in the academy can help to highlight these cases. And once they get highlighted, sir, I think people will get energy to transform and strengthen the system with a single-minded focus to protect liberty, equality, fraternity, and dignity. I think we have 7-8 minutes over the time, although we have finished it on time, but these are some extra points. We have the program has been finished.
Most of the questions you have covered, sir.
Yes.
But again, there's a big question. It can be a full-fledged topic also. The difference between due process of law and procedure established by law. Again.
Yes, sir. We are happy to have a full-scale discussion on that. Sir, as you know, yes. Normally this topic, Constitutional Vision of Justice, we do over one full day, sir. So we have done it in 1 hour, 1.5 hours. So many things have to be done very briefly, but I hope I've not, I've been able to communicate something of value, sir.
Sir,
thank you, sir.
Sir, with this, we come to the questions and reflection and responses. Sir, it's my pleasure to tender vote of thanks. Sir, within a short time, you have consented to deliver a lecture on this webinar. And I express on behalf of all participants and our academy and our collaborating team, SCC Online also, my heartfelt thanks. And sir, my words are not enough to express my thanks. Please accept my thanks, sir, and I request you to come again for another webinar, sir.
Sir, it's a great honor and privilege for me. Thank you so much for the opportunity, Mr. Yaragada. Congratulations on a wonderful initiative on webinars, and also compliments to Mr. Gill, being patient and orchestrating all this. Thank you so much, sir. It's an honor.
Thank you.
Sir, let me express my deep gratitude and thanks to our Honorable Chief Justice, the Patron-in-Chief of our Judicial Academy, our Honorable Director, and for allowing us, for inspiring us to conduct this kind of webinars. And I express my thanks on behalf of all our team and our participants also. And I express my thanks to Honorable Lordships and Ladyships who are participating in this webinar. And my special thanks to the judges from the Sri Lanka, Nepal and Bangladesh who are pleased to attend this webinar and interacted by way of questions also. And my thanks to Honorable Registrar General, Registrars and Judicial Officers of the Registry, our High Court, who have coordinated, and Honorable Principal Judges for all district courts, and Honorable Directors and faculty members and judges in charge of all state academies from all over India, and my brother and sister judges from all over India, and our master trainers who helped others also in establishing the connections. And my regret and my apology to the participants whose questions I think I did not exactly read, but we have covered all the questions. And my special thanks to all of you for posting your questions, and my thanks to all the Sir, many judges are attending this webinar by viewing on this screen arranged in the district courts. My special thanks to the system administrators and all those team staff members who have arranged these webinar, these screening facilities in the district courts. And nonetheless, I am always indebted to the national the SCC online and their team and their senior Suman Malik and the Karan Malik and Sanjay Kapoor and my co-host Chetan for providing this wonderful platform. And they are making optimum use of these webinars and combination of academies and the law publishers. And thank you very much to all of you. And we will join another workshop. Thank you, sir.
Well, I just want to request you to convey my thanks to Chief Justice and Director of the Academy, sir, on my behalf. Convey my thanks.
Sure. It's my pleasure.
Thank you, everyone. We'll close this webinar now.
Sir, are we offline?
I can hear you, sir. I can hear you.
Yes, sir.
Gill, are we